the jurors to listen to the evidence, listen to the mitigation, and hear about Bob Hand's life, and to return a death penalty. This is not an easy thing. This is not a casual thing. It's not a political football. It's one of the hardest things I've ever had to do, to ask my fellow citizens to return a verdict that would result in the death of another human being, but they rose to the occasion, considered the evidence, and did return a capital verdict. He then exhausted his appeals in 2018, state system, federal system, all the way to the United States Supreme Court. Since 2018, he's had nothing left to argue about, and yet he still sits on death row 21 years later. Later this year, it'll be 21 years. I support this bill, saying that the law of Ohio should be thwarted, be able to be thwarted, because pharmaceutical companies don't want to sell the chemicals. Is an abdication of the sovereignty of the state of Ohio, which still has this law on its books. The average time on death row for a death row inmate now is nearly 21 years. This book, which we produce every year by mandate of the General Assembly, details case after case of people who are the worst of the worst, whose sentences are deserved, who are still sitting and waiting their day of justice. This is an exercise in democracy. I am aware of the moral weight of this debate. But this is the law of the land. If we wish to break the promises that we made to the families of all these victims over all these years, if we wish to not keep faith with the jurors that we asked to take this heavy weight on to make a judgment, then we owe it to our society and to all those that are involved to own our decision to change our minds. I recognize that there are people with legitimate and deeply held beliefs that don't think we should have capital punishment. I respectfully disagree with that, having been a prosecutor, having actually had to handle one of these cases. But if our democratic processes are such that we decide that we should break our promise, break faith with where we have been and what we have told society, then we at least owe it to ourselves and to everyone else, including those jurors who had to look deep in their souls to render this verdict and other verdicts like it, to own it and to say we've changed our minds and to express the reasons. The status quo is unacceptable, where we're neither taking responsibility for the judgments, nor taking responsibility for, if it proves that way, our preference to avoid the unpleasant nature of this debate. So my thanks to my colleagues in the legislature for bringing this forward, and I would like to turn it over to Lou Tobin from the Ohio Prosecuting Attorneys Association for his organization's input.
Good morning. I am Louis Tobin. I'm the Executive Director of the Prosecuting Attorneys Association. I also want to make sure that I recognize Champaign County Prosecutor Kevin Talibi, who's the current president of our association. There's not a whole lot that I can add to what the bill sponsors have just said and the great speech that our Attorney General just gave for the need for this legislation. I do want to thank them, the sponsors, and the Attorney General for their advocacy on this and for their support of something that's really a difficult topic that is emotionally charged, and we're happy to have their advocacy. All of us are here today because we believe in the need to find a path to justice for the victims of these crimes. and we're here to speak for people who are no longer around to speak for themselves. We want to find a path to justice and closure for the victims' families, people who have experienced incredible amounts of delay seeking justice for their loved ones. And, you know, we want to find closure and justice for people who have experienced horrible tragedies. Prosecutors want to make sure that the death penalty is accurate, that it's fair, that defendants receive the due process that they deserve. But we want fairness for victims also. I think this legislation is a step in that direction. I think for too long in Columbus and at the State House here, the concept of fairness has been a one-way concept that's been focused on the convicted murderers who are on death row and what fairness means for them. And we do want fairness for them, but that doesn't mean that we have to exclude fairness for the victims of these crimes. We can do both. You know, I think some of the most difficult conversations that prosecutors have to have are with family members who are going through these tragic events. Anymore, the death penalty is almost solely reserved for cases where there have been multiple murders, where there have been murders of young children, and they're difficult conversations, and those conversations and the difficulties are just compounded by the undue delay that goes on, and over and over and over and over again having to explain to victims why a sentence is not being carried out. You know, one of the victims' rights that was included in the Marsy's Law constitutional amendment that was adopted in 2017 that was passed by 80% of Ohio voters is a victim's right to a case that's free from unreasonable delay and a prompt conclusion of the case. And right now it's not possible to say that we're meeting that in terms of what's going on with our death penalty in Ohio. We're failing the victims of these crimes. We have to do better for them. We have to find a way forward, and we think this legislation is the way to do that. We're happy to support the legislation, and we look forward to the debate in the legislature.
We do have copies of the bill that was filed this morning. My legislative aide, JT, has 10 or so. If anybody doesn't, if we run out, just contact our office. We'll be sure to get a copy to anybody who wants to see that. With that, I think we are willing to take some questions as you would have them.
This method of execution has now only been used once in known history in Alabama last week, and obviously officials say it was successful, but as this bill goes through the hearing process, it's going to be scrutinized as any legislation is, but medical practitioners generally won't talk about it because of their general opposition to the death penalty, and the Vets Association has called it an inhumane way to put down animals. So are there concerns about the lack of prior evidence in actually using this on humans?
I think you touched on it. This has been used now successfully in Alabama. The officials who were involved in that execution said it went as they expected it to go. I think it's important to point out that there has been litigation that's gone all the way to the United States Supreme Court where a death row inmate was actually requesting to be executed using nitrogen hypoxia under his belief that it would be a less painless and more humane, in his words, method of execution. We've cited in our co-sponsor request, there's federal courts in Ohio that have looked at this where even defense counsel have said this is a reasonable, humane method to carry out these punishments. And so we don't have that concern today, but that's what the legislative process is about.
Does this bill state that lethal injection remains the preferred method and nitrogen hypoxia is the backup, or is there a choice that can be made?
So the legislation would give the condemned inmate the option to choose between lethal injection or nitrogen hypoxia. However, the bill does say that if lethal injection is not available, as has been claimed for the last 5 years, then nitrogen hypoxia shall be used in those situations.
So, in other words, say the inmate chooses lethal injection right now, they would go forward without any delay in the process of
Making sure I'm understanding your question, if an inmate under this bill says would elect to be executed by lethal injection, if lethal injection drugs are available, then that is the method that would be used. But if a inmate says, I want to be executed with lethal injection, and ODRC or the governor says we don't have the means to do that, then nitrogen hypoxia would be used in that situation.
Representative, you and your colleagues are almost intimating that the Wine administration perhaps has not pushed as hard as they could to get drugs for lethal injection, thus you're forced perhaps to use this alternative. Could you comment on your thoughts about why we've had this de facto moratorium and the role of administration in actively trying to find a way around it?
I look at the evidence that's in front of us. I understand what the governor has said. I've read those articles for 5 years. But Florida has been using lethal injection drugs during that entire period of time. Other states have as well, including the federal government. I think we have a reasonable question as to whether it's actually a impossibility to find those drugs if all the other states and the federal government are able to do so. But if that is really a uniquely Ohio problem, then this bill provides a solution that the governor has, in every article that I've read, invited us to take a look at that issue.
A related question with the, what is it, 5-year backlog, would this bill do anything to, compel the administration to complete a certain number of executions per year? I mean, or is now we have the means, now it's entirely up to the courts and to the administration to actually do it?
This bill does not have any language that tries to compel the executive branch or any other agency to do anything. It simply says that there is another method available so that if these sentences are otherwise able to go through, they now have the means to do it.
Representatives, Attorney General, all of you say that you are pro-life. How do you reckon with advocating for a new method for capital punishment?
Well, I've heard this talking point before. I think it's the worst talking point on abortion and the worst talking point on capital punishment looped together. If somebody really can't fathom the difference between an unborn child that is innocent and a child murderer, I think their moral compass is pretty faulty. And so that's not, I have no problem reconciling those positions.
I know that many people that, good people that I respect that are in the legislature on the other side of this issue cite their Christian belief for their position. I've done a fair amount of reading with both Protestant and Catholic philosophers. I think there's, not only do I agree that there's a difference between an innocent life and a guilty life that has received due process, I also don't believe that, I don't think you can make the argument convincingly that the scripture requires a anti-capital punishment position. There are two things, though. I want to go back to what you said for a second, your question, Daryl. The federal government had a stockpile of lethal drugs at the conclusion of the Trump administration. So I don't think that the federal government has had to procure those drugs. And this gets complicated because the pharmaceutical companies also have other products. And as I understand it, their position is that if the state government were to use their drugs in a manner that they don't want for capital punishment, that they would refuse to sell other drugs. That places the governor in a difficult position. Now, whether calling their bluff would produce a different outcome, or whether they would actually go through with that, is an unknown and a hypothetical. What this does is it changes the trap that we're in, the logical conundrum that the governor would be in. So it's giving him another tool in his toolbox.
Where would the nitrous gas come from?
Nitrogen, not nitrous. Nitrogen is widely available commercially and, in fact, can be manufactured easily. I have no qualms about whether we would be able to secure a supply.
It would be a private sector contract of some kind?
I'm sorry?
It would be a private sector contract of some kind?
I would assume that would be where we would start. I candidly don't think it's outside the realm of possibility that the state could get its own. I mean, there's nitrogen in this room. There's more nitrogen in the air you're breathing right now than there is oxygen. So I think that that's not going to be a problem. I was also asked about whether this is whether it's cruel, whether it's unnecessarily painful. It's important to recognize that Europe is already using this for assisted suicide. So either you have to believe that modern, enlightened, oh-so-sensitive and progressive Europe is condoning the use of a cruel method for those that seek assisted suicide, or actually it is as it's the people up here are suggesting, which is a reasonable way to accomplish this goal. You also would have to conclude that all the people in Europe that have elected this method of suicide are voluntarily undergoing a painful route of doing so when there are other means available in Europe. And I just don't think that that logic flies at all. It doesn't stand up to the first degree of scrutiny.
What does the support for this bill look like, given the companion legislation in the House and Senate to abolish the death penalty?
So the bill we filed today has 13 co-sponsors. We appreciate that level of support in the caucus. When we have talked to our colleagues over the last, however many years we've been in the building, the support for existing law as it relates to capital punishment is very strong in our caucus. Now every year, every General Assembly, we have an abolition bill that gets introduced, and you have a small handful of the caucus that signs on to co-sponsor those bills. A lot of stories get written about that small handful of folks. The bills never go anywhere, and then we're kind of right back where we have been. And so what we're trying to do with this bill is provide an outlet for what we believe is the majority opinion within our caucus, at least, as to how the law should be. There is not support for abolition. That's why it does not pass. We don't believe there's support for abolition in the public, and we believe that there is. Ohioans are asking, these sentences have been enacted. We need to see them carried out.
If this bill passes, how long do you anticipate it will take before execution would actually be carried out with nitrogen gas?
That's beyond me, probably, but
Years, months, decades?
My understanding from talking to the Prosecutors Association is there are around 30 death row inmates who have exhausted all appeals and so are simply waiting for a date. And so if there is an available means, we've seen the schedule in different articles talking about this before, we have executions that are scheduled in this state to go forward. And so if this bill were enacted, those executions could be carried out on the normal schedule.
To what extent?
Yeah, it's a great question. I mean, there's a lot of states that actually do allow for a wide variety of means of carrying out capital sentences. We've spent a lot of time kind of looking at those different states and what we thought would be most palatable here in Ohio. And so there has been a trend over recent years of states successfully providing for nitrogen hypoxia as an alternative. You have that existing case law where there is we have a belief that this is a method that the Attorney General spoke to that is humane and most people would find to be reasonable. And so, we're trying to arrive at a method that can gain the broadest support within the legislature and hopefully pass. Our belief is that this has a better shot than some of the things that other states have done.
To what extent would this require new DRC facilities or equipment, more than something just negligible staff and or training? And, of course, the executive has to go along with that.
I don't want to get too far out over my skis on their facilities, but my understanding reading from other states is that Alabama did not have to, construct some alternative facility, and I don't believe the other states that have authorized this method have had to make any drastic changes to their facilities either.
Attorney General, what is the status of litigation? I remember that I think it was Magistrate Mers that had retained jurisdiction for a while on the protocol. Just by changing this protocol, you automatically end up having to go back to court to defend it?
Well, I'm sure that if this is passed and signed into law, that it will be challenged immediately. That's the nature of the world we live in. I also take note of the case in Alabama, which did go up to the Supreme Court for a request for stay under the Eighth Amendment and was denied. So I think that the legal challenges will come certainly, but I also am optimistic that they would be resolved in relatively short order, absent any kind of unforeseen evidence that doesn't exist now.
And this would be new litigation as opposed to existing litigation that's still open?
Yeah, I think that would be an interesting question if they tried to challenge it under the existing legislation or existing rules, because the complaint doesn't include nitrogen. If they tried to do that, then I think we would probably oppose that on procedural grounds and force them to file a new complaint, but that's pretty far in the weeds.
You've advocated for this being a humane method, but I'm wondering what your thoughts are on that Mr. Smith and Alabama convulsed for several minutes before actually dying.
So obviously I wasn't present as a witness, and important for me to recognize that. Look, the run-up to that execution, the inmate had made it very clear that he didn't want to die by any means. He was in the courts. He didn't want to die by this means. This is a convicted murderer. Yes, I expected that he would struggle against his restraints. The attending physician said that he held his breath. I have no reason to disregard the attending physician's observations. And so I don't think that the behavior of the inmate is indicative at all about the nature of the process and is indicative of the very human instinct to fight for life.
Attorney General, let's talk about financial impact. Your report from, I believe, last year talked about how this process has cost the state tens of millions of dollars and isn't currently working. Do you think that using this new method would alleviate that kind of financial burden, or would this cause a whole other financial, excess from a new process?
Well, it's important to realize that a great deal of the money that gets spent on capital punishment is spent in the appeals process, and appropriately so. Why do we spend all that money? We spend all that money because we want to make sure that every last shred of evidence, every last argument is considered so that we don't make a mistake, an irreversible mistake. And in fact, the system has shown over and over again that it does that well. Now, that costs some money. The question I would suggest is, does the capital punishment warrant, in these most extreme cases, the cost? I would suggest that it does. When we look at the numbers that we spend on many other things of lesser import than life and death, these numbers pale in comparison and are appropriate to make sure that we have a system that has many, many fail-safes, many, many eyes, many, many checks and balances to avoid making a mistake.
Attorney General, this specific method in the lead-up in Alabama, one of the concerns that I read was that because it was not an injection, it was a gas, and the maneuver could potentially be exposed. Would something like that with this new method open the state up to potential litigation if something is to go wrong?
Well, again, there's nitrogen in this room, lots of nitrogen. It is not nitrogen that kills you. It is the lack of oxygen because you're breathing nitrogen. No, I'm not concerned that we might have a few milliliters of nitrogen gas leak out. It will join the rest of the nitrogen in the air.
To the co-sponsors of the bill, besides the Attorney General and the Prosecuting Attorneys Association, what other people or groups did you consult in drawing up this bill?
These are the two groups we worked with. Yeah, this is an idea that Representative Plummer and I have been working on for quite a while, and came to understand that the Prosecutors Association, the AG's office, had similarly been kind of working alongside us, and we sort of merged all those ideas into one and came up with what we have today. Obviously, as part of this process, we expect there will be other groups that will come out in support, and no doubt some that will be opposed, but we feel very good starting out with Dave Yost and the Prosecutors Association.
To the sponsors, is it your understanding that leadership regards this as maybe priority legislation for this year? Or is this kind of the beginning of a debate that's likely to take another 10 months?
I think this is the beginning of a debate. I don't know what, candidly, I don't know what leadership considers to be priority legislation in February of this year. So we look at this as we've got quite a bit of time left in this General Assembly. We get this introduced now before a summer recess. Hopefully we can have an expedited process and have this move forward pretty steadily and be in a position potentially to come back, and certainly by the end of this General Assembly have this passed out of both chambers.
A state Supreme Court task force several years ago recommended a number of reforms in the death penalty application process. Are you open to incorporating some of those reforms into this bill, or is this only going to be about the method?
I think any bill, I've had a pretty open mind as far as if it's a reasonable reform and it's something that has the support of the relevant committee or the chamber. I've never been too precious about keeping good ideas out. However, I think task forces all over the place make recommendations that don't actually have the support of the elected legislature, and so all ears, but we feel like this is where we want to start.
The number you mentioned victims rights here, and not to dwell too much on inmates. I've watched and witnessed numerous executions in my career, and there are times when the victim's family did not want this. They got up at the podium afterwards and said, "This expands our tragedy. This just makes life worse for us. One person died and now another." Do you believe that the death penalty should be optional for families like that that don't want it?
Yes, I think victims' families are an important part of the consideration, but they're not the only consideration. I think society at large, protection of society at large, making sure that our justice system has punishments that fit the crimes that are committed. It's a component, but it's not the only component. And so certainly there are instances where I think a jury and the prosecutor and I think society at large would say that capital punishment is warranted in this heinous situation, regardless of what one particular family member may wish.
Attorney General, you made reference a couple minutes ago about all the expense is worth it on the appeal. You said the process works well, and you mentioned the black book that you released last year. Of course, no one in Ohio has been executed and then later found to be innocent. Keep back. On the other hand, we've had, I think we're double figures now of inmates on death row who have been exonerated through apologies, prosecutorial misconduct, mistakes along the way. Again, the stakes are high. That's in the larger scheme of things. That's probably certainly a minority percentage point. But does that give you pause in endorsing reinstitution of the death penalty in this state?
As you point out, there is no evidence that an innocent person has been executed in Ohio. The exonerations that you mentioned are evidence that the system actually works as it's designed to do. I wouldn't call it well, but as it's designed to do. I'm going to quibble a little bit with the way you asked your question. Does it give me pause? Of course it gives me pause. It gave me pause trying to decide whether to ask for the death penalty in Bob Hand's case. I wrestled with that. It was hard to ask the jurors to join me in that decision. This is not something that should be taken lightly. But at the same time, there are crimes that are so heinous, that are so against basic humanity, that they deserve the ultimate punishment. I want to add one more thing that is important to this debate that no abolitionist has ever successfully explained to me why this is not true. Take a prison guard or a social worker, if you prefer, who works in prison and he's got or she has a LWOP prisoner, somebody who's already doing life without parole. He decides he's got a free ticket because there's no death penalty. So he decides to take out that social worker or that prison guard or cook or whoever it is, somebody who's innocent, who's done nothing wrong, who has family and children and grandchildren perhaps of their own. What's your penalty for that person? The answer is you have to have death penalty at the very least in that situation. That eliminates the abolition argument because you have to have it at least for that. Now that we've established that it has to exist, we're going to discuss when should it be applied. Now, it may be that it should be applied more narrowly or with different kinds of processes than we now have. But the notion that we're going to do nothing is to consign the prison population, or excuse me, the people that work in our prisons to open season. That's a ridiculous outcome.
Jenna, could you address my victim's rights question, and specifically, is there sometimes a crime so heinous that the prosecutor should pursue the death penalty even if the victim's family doesn't want it?
That is a very tough decision, and I think that out of 88 prosecutors, they would probably weigh the equities differently, 88 different ways. Speaking only for myself, I cannot imagine I would exercise my prosecutorial discretion to ask for a death penalty if the survivors of the family had forgiven the murderer and asked me not to. But I will admit that that's a fraught and difficult question, and my colleague would have a different take on it. Do you want to address that?
I think that's a difficult question to ask. It's impossible to answer. It's going to be dealt with on a case-by-case basis, and each of the elected prosecutors throughout 88 counties in the state of Ohio will have to go through a consultation process both internally and also with the victims and the victim families and their survivors, and make that decision.
Attorney General, have you...
Can I just add one thing to this? Victims are not a monolith, obviously. Some victims are not going to want a death penalty, death sentence imposed. Some might. And I'm thinking of one case in particular where it was a recent death penalty case where there were multiple murders, multiple victims. One group of family members wanted a death penalty. The other group of family members did not want a death penalty. And ultimately, the prosecutor decided, look, it's in the interest of public safety and in the interest of our community to seek a death sentence in this case because this person has committed multiple murders. They were on parole when they committed the multiple murders. This is not somebody that we can have or risk being out in society anymore.
Well, you're up there, and here you go. I'll give you a chance to answer this too.
Darrell, I think Paul was in front of you.
Oh, I'm sorry.
No,
Go ahead.
that's cool. The question was, since you just mentioned it, have you thought substantively about whether the death penalty should be applied more narrowly or with different processes, and what might that look like? I mean, even as a hypothetical, have you actually thought about that?
So I actually think that we've had a great deal of debate and think that the current system doesn't need a lot of tweaking, as my personal judgment. Now, that being said, this is a subject for the deliberation, not of the Attorney General, but of the General Assembly, which is to reflect the sentiments broadly of the people of Ohio. So if they were to come in and, change the weighting of the consideration of mitigation, if they wanted to make certain offenses ineligible for the death penalty that currently are eligible, that would be up to them to do. My sense is that the people of Ohio support a limited death penalty for the worst of the worst. And candidly, the last number of years, the discussion has been initiated and dominated by the abolition movement. The people that have argued in favor of capital punishment have largely been in a reactive mode to those that are pressing for abolition. That changes today. The arguments are going to be made for the justice of this current system. The arguments are going to be made for the righteousness of this ultimate penalty for the worst of the worst. And we're going to have a debate that's long overdue, and I hope that the legislature gives us an answer. I hope it's the answer that I want. But even if the answer is abolition, we as the people of Ohio deserve a considered and direct answer to what we believe to be the right direction, and that is your charge, gentlemen.
Last question.
Attorney, Mike, can I get it in? I still wonder whether some people would be troubled, Attorney General, with your statement about the exonerations or evidence the system is working. It seems like that's only if you count, the Ohio Innocence Project, a lot of news media groups who doggedly and through great investigations turned up evidence. I mean, I don't know how you include them in the system as far as certainly the statutory. Sure, they got new appeals and they were proclaimed innocent, got hundreds of thousands of dollars from the state, what have you. I don't know that any of those came from all due respect, a prosecutor saying, we didn't blow that motor, or it turned out there's a false statement or whatever. That all seemed to be from outside the system.
So first of all, our system doesn't run on prosecutors. Our system runs on prosecutors and defense lawyers and appellate defense lawyers and jurors and judges and appellate judges and Supreme Court justices and an entire federal habeas process. And the Ohio Innocence Project is part of that defense mechanism. Now, if you want to argue that that ought to be publicly funded instead of, that's a separate question. But of course they're part of the system. It's an adversarial system that produces these outcomes. I also want to correct you. People use the word exoneration very loosely. In Ohio, you don't have to prove actual innocence. The law now is simply that you have to prove that there was a fault. And we've seen situations where an old conviction that is being counted as an exoneration had some kind of maybe a Brady problem. I'm not excusing that. There's no excuse for violating Brady. But that doesn't mean the person was innocent. But because of the passage of years, the evidence, the witnesses, it's not able to be tried anymore. And a prosecutor has a duty not to bring a case that they believe cannot be proven beyond a reasonable doubt. So they fold their tent, not because the person was actually innocent, but because they were technically innocent. Again, I'm not diminishing the importance of any of that, but you're raising this issue of exoneration. Yes. Yes, it used to be actual innocence. So I want to make sure I give Lou an opportunity.
If I could comment on this, as I said in my statement, look, prosecutors want the death penalty to be fair. They want it to be accurate. and they want defendants to receive the due process they deserve. The last thing any prosecutor wants is to convict an innocent person, let alone put an innocent person on death row. If you look at the way the death penalty is used today, prosecutors want to be assured of the person's guilt before they charge them with a death specification and pursue the death penalty. I think I've lost my train of thought. I guess I'll just leave it at that. You know, prosecutors want to be assured of their guilt. I think even during, I've regained my train of thought, even during proponent testimony on the death penalty repeal legislation during the last General Assembly, former public defender Tim Young acknowledged during testimony that the death penalty today isn't about guilt or innocence, and it's not. It's about whether the mitigating factors outweigh the aggravating factors of the sentencing phase. And so recent death sentences, there's been absolutely no question that the person who is charged with is facing a death sentence has committed the crime. There's none. And if there are people who are currently on death row who there are questions about, there are safeguards in place, whether that's through the appellate process or whether it's through application to the governor for clemency or commutation of sentence. Tossing out an entire sentencing scheme, an entire death penalty scheme on when we're assured of the guilt of people who are being sentenced to death today is just bad public policy.
Representative Stewart, how long have you been working on this bill? And had you looked at other methods of execution prior to what happened in Alabama last week? Would we be here today if things had not gone well in Alabama?
We've been working on this for, I think Representative Plummer had a draft for the last year. I've been working on it sort of in the abstract. I think we had planned to introduce this regardless, but it certainly the successful use of the process in Alabama was kind of coincided with when the bill was done, and felt like this was a good time to get it introduced. Thanks everybody for coming. Thank you.
I want to hear your question.